there's work done on the casing, unbeknownst to co-counsel, myself, obviously I was not on the case. They ended up doing a further examination of the casing. That examination revealed that, in fact, the two casings are consistent with having been fired. They're 9mm casings from certain 9mm handguns. There are some markings on the casings that are somewhat unique. They can basically track them down to a much smaller subset of firearms that could have caused the marks on the casings. Included in that is Glock 43. So, hold on. Okay.
Did the report say that the casings could only have been fired from a Glock 43, or could a Glock 43 be among the type of firearms that the expended casings could come from?
Let me read the exact conclusion. Items 1A and 1B.
Those are the casings.
Those are the casings. Each exhibits characteristics typical of aftermarket slides for a series of subcompact pistol frames, including but not limited to Polymer model PF9SS, Glock store model SS.
Wait, slow down because the court reporter needs to take it.
Sure. Polymer 80 model PF9SS, Glock store model SSA, and Glock model 43 and 43X. We have been given information that, in fact, oftentimes and frequently when you're looking at casings, you're not able to get a whole lot of information. But it turns out that the markings on these casings are a bit more unique, and they are not only consistent, but the examiner will testify that the markings he has seen very rarely, and that where he has seen them, where they've been recorded, are with a Glock 43 pistol.
What's the name of the examiner who did this ballistic comparison?
The examiner's first name is going to be F-I-D-A-L, last name B-I-R-A-I-M-A-H. B-I-R-A-I-M-A-H. So the way this came about was, we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report that we're talking about,
Which detective?
in the attachment.
Detective Flores.
Flores?
Flores.
From Every Homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report. So he goes back in discovery, looks at emails. We don't have a report. So we instantly contact the defense, send them out the report. I want to be clear. The report is inculpatory, not exculpatory. So obviously, not only do we have no motivation to have not turned over this report, RHD has no motivation either. What's very clear is that they believe they had turned it over, and they did it.
What time did Detective Flores bring this to either your attention or Mr. Frizzoni's?
Yesterday afternoon, you want the exact time?
Approximately.
It was yesterday afternoon. We were in court. We went back to the office after court yesterday, and that's where we went back and looked to see, do we have this discovery?
So something after 4:30 p.m.?
The email is timestamped 3/18, but I got it when we, so it was essentially received but not gone through yet until I could get back over to my desk.
You conveyed this to the defense when?
We sent it to them at 5:21.
So about 40 minutes later, thereabouts?
Because the first thing we had to do was, we had to go back and see, have we already turned this over? So we not only emailed it, we called them. We explained the situation. The response at the time that we gave it to them initially was, well, you know, this is the same thing that you have accused us with respect to the witness and the court's finding that they violated the court's discovery order. And we responded, no, this is completely different. You had interviews starting last August.
I don't want to get into who said what. I just want to know the sequence of events.
So at this point in time, we had a discussion. We sent an email.
Why are you not investing in tax liens? No, seriously. Why are you not investing into one of the most incredible real estate strategies that's the most passive and creates the highest rate of return? Now, I bet you're thinking, Brian, I don't even know what that is. And even if I did, I don't know how.
Sent an email at that point to counsel, and we included the court. There was an email sent late last night at some point by Mr. Tacopina. I did not see it until somewhere around 1, 2 in the morning. In that email, Mr. Tacopina cited the Hughes case. There were no facts in the Hughes case. I went in the middle of the night, I got the case, I read
I
it.
don't want to know about, this would be appropriate if you want to argue your position. I just wanted to know the sequence of events.
Right, I'm not going to go any further other than to tell the court. I read the case, I then sent an email at roughly 3 or 4 in the morning. I sent it to counsel and I sent it to the court.
All right. The last, can I have just one last factor on it, which is I knew from past experience with firearm analysis that there would be a lab file or bench notes associated with the analysis. So I tried to immediately contact the lab to expedite and see if they could send that to me immediately, but they were not open at the time that I called. So we had to call this morning at around 6, and they scanned it and sent it over, and I sent that to the defense as soon as I got it.
How many pages is this report?
The report is 1
The
page.
report itself is
It's
1 page.
1 page. How many pages are there total of all the police reports, all of the discovery of this case? How many pages?
Regarding this one,
Regarding the total number of,
regarding this one.
No, I was.
no, the total number of pages involving this case and this investigation.
I would estimate 100 or over 100 pages. I mean, to be totally candid with the court, I haven't counted them, but that's just ballparking the various reports and things that we received.
All right, I understand now the sequence of events. All right, who wants to speak to the defense?
I think, I'll start. Maybe Mr. Siegel, I leave something out as we tackle this together. I mean, we spent literally the night before opening this, about 5 hours.
Okay. Speak slowly. The court reporter needs to get everything down, and I want everybody to know exactly what you have to say. Go ahead.
So, and I'll just stick with sort of the chronological order here. I'm not going to argue case law or anything like that, but aside from the fact that we lost 4 to 5 hours the night before opening dealing with this, we this morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report. He testified at the preliminary hearing. After we get that report that says, in conclusion, that the subcompact pistol frames, including but not limited to, which means absolutely nothing. So it could be a universe that we don't even understand of other pistols, and then goes on to list 3 of them here. This morning, we got another 28 pages of backup data on this. backup lab, I guess, report that normally comes with a conclusion report. We got this morning. And I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. We have an issue now with the jury. Obviously, it's a jury panel. It may affect, quite frankly, whether we would have kept or not kept a few jurors, one in particular. Now, we assured him yesterday he'd have a fair trial. You're going to have a fair trial. We've made issues regarding the veneer. You know that, Your Honor. I'm not going to rehash that. We're here. We're ready to vote today. I don't even know how we're supposed to do this. This should be suppressed without question, because it changes the complexity of the case. At the very least, we have to quash this panel and start again, or strike jurors, reselect. I mean, I think even the district attorney said, well, okay, well, continuance is appropriate. We paid the jury. We're ready to go. This is something that, you know, to render fair and effective representation here, as we all assured Mr. Mayor we would have, in the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. 1 week. And that's their own lab, with their own on-staff experts. And it took them a week. How long is it going to take us? We have to go find somebody first, hope he's available, the trial will be over. We also have to make arrangements for the physical examination of the casings, scientific testing. I mean, if you look at their report, I mean, they cite like some of the basis for their findings is of the internet. They went on and cited all these websites and forums. I mean, there is so much work to be done here to even understand this conclusion. I mean,
All right, so what do you think?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our letters laid it out. I don't need to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to.
It's crushing us. A housing crisis that hurts our families. Now it could get even worse. So many New York
We have to either break this whole panel. We need a continuance. We have to start again. What I'm asking for is you include this. This is after the jurors panel. This is a major piece of evidence that will require us to do a lot of expert work that took them, their own department, a week to do. That's the only thing I'm requesting. Short of that, Your Honor, I can't even open if this is coming in, because I have to deal with the address. I don't even understand it. And it's we got on the way to court, we have 28 pages of backup data. So that's what I'm requesting. I'm requesting this to be included. It's get the jury's panel here. You know, Seal has pointed out, you know, there's also a balancing argument under 352. You know, which I think is also something that's relevant here, including not limited to. But you know, we have this whole. I don't know what to say here, Your Honor. I really don't. I want to make sure he gets a fair trial. He's here, we're ready to go. We all assured him he'd get a fair trial, and this is, I've never seen anything like this. I'm not going to talk about the other witnesses, the late Brady disclosures, or the witness we got the name of for the first time last night. I'm not whining about that. I know that's what they want to keep doing. We both have had issues with that. That's fine. I will not make it an issue of it anymore. You've already ruled on that. Period. End of story. This is now a new one. You know, I don't want to get into, I told you so. Many people said to me this morning, I told you so. that this was going to happen. And I'm trying to keep my composure, Your Honor. I don't know if I've ever been this upset in a courtroom in my whole career, both as a prosecutor and a defense attorney. I got to be honest with you. This is not right. It's not fair to him.
Hold on. Mr. Siegel, did you want to?
Yeah, the only thing I wanted to say.
I don't want you to repeat what Mr. Tacopina said. If you want to add something new,
No,
you're welcome to it.
I want to add something new. So I dovetail what he said with respect to the 352 arguments, and that is the report says that the characteristics include or not limited to certain firearms. That means the universe of firearms in this case, based on the face of that report, is extensively broad. So given that, Your Honor, I think even just the probative value of this is substantially outweighed by the danger of undue prejudice, separate and apart from the late disclosure. So it should be excluded on 352. But that's secondary to the fact that it's just incredibly late at this stage for all the reasons that Mr. Tacopina said. So I'm just adding an additional factor.
All right, what I'm hearing from you then, it seems like you're talking out of both sides of your mouth with the defenses. Like it's irrelevant. However, it's so prejudicial that it shouldn't be allowed in. It's so inculpatory that it shouldn't be allowed in.
No, I don't think anyone said it's so inculpatory. We don't understand. Saying it's inculpatory is not accurate. I didn't say it's inculpatory, he didn't say it. What he said was there's a balancing test because it says including but not limited to. All that simply means is not that it's not inculpatory, not that we just don't understand what this means. Not limited to means there's a universe of guns that have to be tested now. I don't know what not limited to means. So how many pistols does not limited to include? How many firearms does not limited to include? That's what it means.
Okay, who wants to speak to the people? Go ahead, Mr. Long.
I want to take things one step at a time. Council brought up a nice comparison to what has happened thus far.
Just a minute. Alex, could you please go out and tell the jurors that we're dealing with some logistical matters, and just to please be patient, and we're going to have them come in as soon as possible.
Yes, sir.
Go ahead.
One, as the court is aware, there is no logical reason why either Robert Hamadai's division or the DA's office would have in any way not turned this over. It's very clear that this evidence only helps our case. So again, as the court pointed out, on the one hand, Mr. Tacopina says, client cannot get a fair trial. This is so apparently damaging. Yet on the other hand, he says, hey, it doesn't really matter because it includes so many other guns that it should be kept out as being irrelevant. But what's very clear is, and I didn't appreciate the comment, when Mr. Tacopina suggests that he can't believe that the DA's office did not know about this in advance, when I spoke to him on the phone last night, that is not what I heard. What I heard was, hey, listen, this is a problem for us. We understand, I'm going to quote Mr. Siegel, yeah, there's no reason why you would have not turned this over if you had it, which is correct, and the record is supported. Comparing this, counsel is now discussing and saying how they are being victimized by late discovery. The only late discovery in this case, and the court's aware of it, the court ordered that the discovery be turned over on 2 witnesses. It should have been turned over before the court ordered it.
I don't want to deal with something that we've already dealt with. I understand about the 2 defense witnesses. We've covered that.
Right.
Just deal with the present issue.
So, what counsel did is, he cited last night, he sent to the court a case called
Hi, my name is Sarah,
And I'm Scott.
and we'd like to congratulate you for taking the first step towards your recovery.
We are so excited you've chosen to begin your journey with us.
called Hughes. 2020 case, 50 cal at 5th at 257. He included no facts about that case. At 2 in the morning, I went and I read the case. And I then sent an email. That case, so the record is clear, involved a situation where there was a Watson murder and where the defendant was being tried on a theory that his alcohol intoxication had caused the accident. Investigation had been done by the MATE team, and they had determined that in fact it was speed and not alcohol. This was a very huge problem for the prosecution because that was the theory of their case. Apparently, the head of the MAID team started redoing a separate investigation, which the evidence suggests the prosecutor was well aware of. At the very least, and as the Court of Appeals said, the prosecutor was given information that in fact the MAID lead detective now had a new opinion contradicting the prior opinion that in fact, in actuality, it was caused by alcohol and not by speed. Instead of turning this over to the defense, the prosecutor literally had the witness on the stand in front of the jury. He then pauses, looks over the fence and says, hey, by the way, here's the diagrams and here's the information that he's going to be testifying to. Defense is obviously horrified because it's the entire case. The defense asked for a mistrial. They asked for a continuance. They were both overruled. The Court of Appeals said, hey, listen, obviously the suppression of evidence, as the court is aware, and under the statute, is the last option a court can utilize, only after every other option has been determined to be not harsh enough or not accurate enough in addressing and solving the situation. The Court of Appeals said, hey, listen, Judge, you had a chance to do less remedy. You didn't do it. The jury ended up convicting, and the case was reversed. To compare that case to the facts of this case, it is distinguishable for the following. Number one, that evidence was not just inculpatory, it was the entire case. Number two, the prosecutor, for a tactical advantage, which the Court of Appeal basically said in a footnote, that although the original trial judge had found no prosecutorial misconduct, that in essence the record didn't support it, meaning that there was misconduct that the prosecutor did. The prosecutor decided, for a tactical advantage, that he was not going to turn it over. He then did it while the witness was on the stand. He then opposed any continuance or mistrial. I wouldn't turn it over, and as soon as we had it, we turned it over. And as the court's aware, I've been trying cases in front of His Honor for going on 30 years. As soon as we found this evidence, we contacted the court. Or counsel, and they can hire any qualified firearms expert. I want to distinguish between Hughes and this case. Hughes investigation. This is very minor and simple ballistics interpretation. So we will make it available. We already have sent our investigators to recover the evidence. I don't know if they already have it.
I believe they've already.
We believe they already have the evidence. They have it with them. And we will get it to the defense. I just, this is related to the other issue, so I just want to make sure that this is clear. Counsel seems to be under the impression that the court has now changed its ruling and that we are not allowed in our opening statement to address the idea, which the court previously ruled we could, that we did not find out about this defense until the 20th. The court had said previously on the record, yes, Mr. Lewin, you guys can address that issue in opening. I will decide whether I'm going to issue a discovery instruction later. Counsel believes you've now said we can't do that.
I did say that.
Yes, they did. Yeah,
I did.
co-counsel myself, I would say was not on the case.